All right, welcome back. We've got what I think is a fun one today, and it's a brand new lawsuit. Yes, for those of you who are new, I did say lawsuit because it's hilarious. Um, Not for the people being sued, of course, but it's a really, really, really bad lawsuit, and so we're going to cover it. And so thus far, the only thing filed is the complaint. We don't even have proof of service yet. So literally one thing on the docket. And so this is about the Lauren the Mortician, who is a mortician, obviously, who posts mortician related videos on TikTok. And so I've been made aware of basically like, well, let's back up. So, for those of you who are new, let's start there. For those of you who are new, I'm Joe. I'm an attorney licensed to practice in the state of Utah. This is in Illinois. So, that being said, so I've been kind of aware of the beef with Lauren the mortician and her lawyer, who is her co-plaintiff, and their beef with fellow YouTubers, TikTokers, Instagrammers, whatever. I don't know. I had never heard of any of them before, but for those of you who have followed my coverage of the TikTok psychic case up in Idaho, um, well, that case introduced me to the YouTuber Marky. He's a young British commentary channel. He does a really good job of summarizing YouTube beefs and controversies and whatnot. And so he has done a very good job documenting the ongoing situation. And due to my experience talking about, false copyright strikes with delete laws, well, I thought, since lots of this is about what looks like, at least at first glance, false copyright strikes, I should sometime in the near future take a look at the videos that have been struck and, give my opinion. Now, I'm not a copyright attorney, but, I've looked into it enough. It's, I know the law. So I do think he hasn't made a video in a while, but people need to make Leonard French, Lawful Masses, aware of this because this is right in his wheelhouse. After all, he is everybody's favorite copyright attorney. So, either way, I had been meaning to, once I had time, do sort of a review stream of the videos, give my opinion on whether it's fair use. So, but in the meantime, the lawsuit happened. So, either way, for those of you who are not familiar with the beef, I do suggest you familiarize yourself with the situation by visiting Marky's page. Marky, absolutely charming young guy. Go give him some views. Although I need the views more than he does, but just looking at his videos, the TikTok mortician lawsuit is really bad. The TikTok mortician keeps getting worse. Um, 9 days ago, the TikTok mortician situation gets worse by the day. 2 days before that, TikTok mortician police calls leaked and prove her lies. Now, we'll take a look at that probably in the next video on this subject. Today, we're just going to really look at the complaint is going to be the main thing. But, 2 weeks ago, TikTok mortician situation just got a lot worse. 3 weeks ago, TikTok mortician ruins her career with disturbing lies. And so, yeah, that looks like the first video he made up on it. I didn't count. That's 5 or 6 videos. He does the standard 10 to 15 minute video. So, like I said, go watch them. You won't regret it. He's good. So with that, let's go to the docket. So we have Braun. I'm going to struggle not to pronounce it Brown, but from the police phone calls, she pronounces it Braun, not Brown. So Braun versus Day. And that is Jeanette Braun, the TikTok Lauren the Mortician's copyright lawyer. This I foresee ending badly for attorney Braun in multiple ways. So this is in the federal district court. What was that? What on earth? Something just fell. And I have no idea what it was. So, yeah. Sorry about that. No idea what that was. But let's keep going. So yeah, this is in the federal district court for the Northern District of Illinois. So makes it easy to follow because, PACER is a lot easier than state courts getting documents from state court, which is one of the reasons I haven't covered the Illuminati case yet, although I'm still tempted to, but I don't do redacted documents, so I'd have to request them from the court rather than getting them from Mad Catster like everyone else has. So, yeah, Northern District of Illinois, Federal District Court. We have the complaint. It was filed December 15th, 2023, so just a week ago, and it's bad. It's really bad. And it, surprisingly, well, it would be really bad if Braun were the attorney of record. She's not. She's a plaintiff and an attorney, but they jointly hired a different attorney. This is still going to be really a bad situation, and we'll discuss that further as we go along. So yeah, so I did give it a brief look, and I titled the video Lauren the Mortician slaps, sues her critics. So I did a quick review of Illinois' slap laws. They have one. It's not particularly strong. It was passed in, I think, 2007. Originally, the courts gave it some real weight, but ever since, I can't remember the name of this lawsuit, but the Illinois Supreme Court really neutered the slap law. So it's still there. It still can work, but it's much less likely to. But from what I read, you even without the slap special motion to strike, you still have, if it's a slappy suit, a decent chance of getting it dismissed on summary judgment pretty early on. So I have a feeling that's kind of where we stand in this. But like I said, we only have the complaint so far. And so let's go to the complaint. So in the United States District Court for the Northern District of Illinois, Eastern Division, Jeanette Braun, Braun IP Law, LLC, and Lauren Propson as plaintiffs. Lauren Propson is Lauren the Mortician, versus Rebecca M. Day, née Box, Casey, the owner and operator of the online social media account Caffinated Kitti, Lily Marston, and Jessica Vasquez as defendants. And so this is the complaint and demand for jury trial. Plaintiffs Jeanette Braun, attorney Braun. She's got to hammer that home. She's an attorney. That doesn't really matter. But she's got to say attorney Braun every time just to hammer that home instead of just Braun. So plaintiffs Jeanette Braun, attorney Braun, Braun IP Law, LLC, Braun Law, and Lauren Propson, collectively plaintiffs, present their complaint against Rebecca M. Day, née Box, Day, Jessica Vasquez, and Lily Marston, and KC, the user and operator of the social media accounts Caffinated Kitti, KC or Caffinated Kitti, and alleges as follows. And we have footnotes 1 and 2. The owner and operator of the social media account Caffinated Kitti has not publicly disclosed her real name or identity. For the purposes of this complaint, the defendant is referred to as KC or Caffinated Kitti. Wouldn't that be CK? That doesn't make sense. Either way, footnote 2, the social username @Caffinated Kitti intentionally misspells the word caffeinated by not including the letter E after the second F. That's good to know. So, nature of the case. This is a diversity action asserting Illinois state law claims for defamation per se, trade libel, false light, intentional infliction of emotional distress, and tortious interference with business interests because of defendants' publication and dissemination of slanderous and defamatory statements regarding the plaintiffs that were false, harmful, and offensive. The parties. Plaintiff Jeanette Braun is licensed to practice law in Illinois and operating the law firm Braun IP Law, LLC, in DuPage County, Illinois, and resides in Illinois on a part-time basis. Plaintiff Braun Law is a limited liability company organizing and existing under the laws of the state of Illinois, with a contact address of 1600 West Lake Street, Suite 103B in Addison, Illinois. And I probably shouldn't have read the address, but it's a corporate address, so who cares? But this is a good time to give my normal disclaimer. This is not a petting zoo. This is an animal safari park We keep our arms and legs inside the ride at all times, meaning do not contact any of the parties involved. It's not a petting zoo. We laugh at them on the internet. We laugh at them in the comment section below this video. We don't contact them, any of them. Understood? Good. Of course, that being said, from what I have seen, I would not give a glowing recommendation of Braun Law. And Ms. Braun, that is my opinion. You can't sue me for it. I should make that very clear multiple times. Everything here that is not written in the complaint is my opinion. It's based on my legal analysis, but it is my opinion. Opinion is protected free speech. It's not defamation. Which is, I say that because it would appear to me that Ms. Braun does not understand that, which you'll see as we continue on with the complaint. Plaintiff Lauren Propson is a citizen and resident of the state of Wisconsin. Upon information and belief, defendant Rebecca Day is a citizen and resident of the state of Missouri. Upon information and belief, defendant KC is a citizen and resident of the state of Georgia. Upon information and belief, defendant Jessica Vasquez is a citizen and resident of a state that is neither Illinois nor Florida. Upon information and belief, defendant Vasquez is a victim of certain crimes, and out of respect to her privacy, plaintiffs request to not directly plead Ms. Vasquez's current state of residence. Upon information and belief, defendant Lily Marston is a citizen and resident of the state of California. So, why is it important that they go over the residence of each plaintiff and defendant? It's regular viewers will know this already, but this is brought under diversity jurisdiction, which, I mean, that they already said that above in the complaint. This is a diversity case. But for those of you who are new, let's look at what that means. So 28 U.S. Code section 1332, this funny little squiggle means section in legalese. And that's diversity of citizenship. And this is the requirements for diversity of citizenship. Because basically, federal courts, there's a presumption, a general presumption, that the federal court does not have jurisdiction to hear a case. It doesn't have the legal authority to hear the case unless it is specifically granted jurisdiction under some law. So often, well, federal courts have jurisdiction to decide issues based on the U.S. Constitution. It has jurisdiction to hear cases involving U.S. federal statutory law. So with those, it has jurisdiction. But defamation is not federal law. In most cases, it's not even statutory law. It's common law. It's based on the English common law, and it's based off of centuries of court decisions developing the concept of defamation. And more traditionally, that would be slander and libel, though they still teach slander and libel in law school. I think it's becoming kind of archaic. You'll generally just see defamation. But either way, it's state common law. So the court that is presumed to have general jurisdiction to hear that case would be the state court, and the state court of general jurisdiction. So here in Utah, that would be the Utah, here in downtown Salt Lake City, it would be the Utah 3rd District Court. In like we watch a lot of videos up in Michigan, it would be the circuit court in Michigan or in Maryland, or in some states it'll be the superior court. In New York, it would be the Supreme Court, because that's the general trial level court, the general jurisdiction trial level court. But diversity jurisdiction allows these cases to be heard in federal court, but there are a few requirements. So just reading the statute, Section A, the district courts shall have original jurisdiction of all civil actions where the matter in controversy exceeds the sum or value of $75,000, exclusive of interest and costs. So we're going to see that figure, $75,000, in the lawsuit. Now, for those of you who have watched my coverage of Schofield versus Giard, the TikTok psychic, we saw in the complaint that figure, $75,000. So lots of people, including Marky, he's a great YouTuber, not a lawyer, a Tozy, that lots of people were saying TikTok psychic sued for $75,000. And so I was all over the comment section saying, so they're suing for a lot more than $75,000. They just put at least $75,000 in damages because they have to, otherwise the court doesn't have jurisdiction to hear it. So, and we saw that in Schofield versus Giard, in the motion for a default judgment before Giard, did her motion to set aside the default and participate in the case. But Professor Schofield asked the court to grant her a judgment of almost $2 million, a whole lot more than $75,000. But for diversity jurisdiction, you must ask at least $75,000. And also, as we've seen in Schofield versus Giard, sometimes you can fight. Well, there's absolutely no way this can be a claim for $75,000. Now, Giard has tried to argue that. She has failed, because it's really for the jury to decide how much damage has been done. The Cardi B versus Tasha K lawsuit, same thing. I didn't cover that one, but Emily D. Baker has. So the only real way you can show that, well, you have to show that there's no way it could be $75,000 to get it dismissed for lack of jurisdiction under that part. And that's going to be like, we had a contract and I was to pay them $50,000 for the widget, and I never received the widget, so I want my $50,000 back. Well, $50,000 cannot be $75,000, so you wouldn't have federal jurisdiction. So, and then it has to be between citizens of different states, citizens of a state, and citizens or subjects of a foreign state, citizens of different states, and in which citizens or subjects of a foreign state are additional parties. And so that, yeah. So basically, that's what we need. The parties have to be from different states. We have to have complete diversity. Now, in order to have complete diversity, basically all of the plaintiffs have, well, none of the plaintiffs can have a domicile as that's the same as any of the defendants. So you noticed Jeanette Braun, Illinois, at least part-time. That doesn't, I don't know that establishes that as her domicile. So this actually could be partly problematic, although that depends on which state her other part-time residence is. Because if it's Missouri, that could be a problem. Or Wisconsin. Well, not Wisconsin. That's fine. So if it's Missouri, it's a problem. So that could actually be interesting because she just says she resides in Illinois part-time. She doesn't say where her other one is. If I'm maybe filing a motion for clarification saying, hey, what's your domicile? What's your other residence? What state do you have a driver's license in? What's your domicile? Where do you vote? That could be an important issue here. I didn't see this when I watched Ian Runkle of the Baileys coverage of this, but he does a very good job, but he's a Canadian lawyer, so he wasn't necessarily paying attention to this, but this could be important. So either way, for now, we'll say she's an Illinois resident. Braun Law is an Illinois LLC. So either way, Illinois is probably an appropriate venue because at least one of the plaintiffs is there. And then Lauren Propson, Lauren the Mortician, is a resident of Wisconsin. So on the plaintiff side, we have Illinois and Wisconsin. But if we have potentially Missouri, that's going to be a problem. Because on the defendant side of the V, we have Missouri, Georgia, who knows? Either, but not Illinois or Florida. Is it Wisconsin? Is it Missouri? We don't know. But if it's Wisconsin, that could be a problem. And then California. So from the looks of it right now, we have complete diversity. But it might not be. So that's going to be interesting to see. Especially, let's see. Addison, Illinois. Okay, so Addison is a suburb of Chicago, Chicagoland area. So it's a bit of a trek to Missouri, bit less to Iowa, not much to Wisconsin or Indiana. So either way, I'm probably asking for more clarification because there might not be diversity jurisdiction here, at least not complete diversity. But either way. So, jurisdiction and venue. This court has jurisdiction over the subject matter of this action pursuant to 28 U.S.C. Section 1332, as this action is between Plaintiff Braun, who is a part-time resident of and owns a business in the state of Illinois, and Braun Law, an Illinois limited liability company, against defendants K.C., Day, Marston, and Vasquez, who, upon information and belief, are citizens of various states, including Missouri, Georgia, and California, and the amount in controversy exceeds $75,000. So we already looked at 28 U.S.C. Section 1332, the statute for diversity jurisdiction. Venue in the Northern District of Illinois is proper pursuant to 28 U.S.C. Section 1391, because Plaintiff Jeanette Braun and Plaintiff Braun Law are in this district, and the reputational harm to Plaintiff Braun and her legal practice occurred in this district. In accordance with Rule 20A1 of the Federal Rules of Civil Procedure, Attorney Braun, Braun Law, and Propson join in bringing this action as their claims arise out of the same transaction, occurrence, or series of transactions or occurrences, and the questions of law or fact common to all plaintiffs will arise in this action. And that is true. So Federal Rule of Civil Procedure 20 involves joinder of parties and basically when you can be co-plaintiffs, when you have to be co-plaintiffs, when you may be co-plaintiffs, that sort of thing. But like I said earlier, as a spoiler, we'll get to it later. Being co-plaintiffs with your client could lead to a bad time. Like, we're talking loss of your license, bad time. Defendants K.C., Day, Marston, and Vasquez are properly joined in this action pursuant to Rule 20A2, as their involvement in the same series of transactions or occurrences and the same questions of law or fact are common to all defendants. Background. So it's important to remember that this is one-sided here. This is the allegations by the plaintiffs. To quote Emily D. Bekah, a complaint is allegations and shade. You've got to believe it to be the truth, but you know, it's generally not going to be the whole story, and your interpretation of things is, you know, you're going to at least try to interpret things the best way you can for yourself. And I don't see this as particularly strong, even in the form of allegations and shade. So I look forward to the answers, or more appropriately, the motions to dismiss, the potential special motion to strike, the slap motion. It could be fun. So defamatory statements against plaintiff Lauren Propson, PKA. I've I've never heard of. Oh, I guess that's professionally known as. I so I'm used to AKA, but professionally known as Lauren the Mortician by defendant KC, professionally known as at Caffinated Kitti. Ms. Propson is a licensed mortician and operates a social media account known publicly as Lauren the Mortician. Ms. Propson posts social media videos and commentary that brings awareness about common safety issues causing death. Her content provides light-hearted and educational videos that discuss death, the loss of loved ones, and demystify occupations and professions that work with deceased persons. In her social media career, Ms. Propson amassed millions of followers on the social media platform TikTok, as well as sponsorships and monetization of her videos. Yeah, the goodwill she's building is going to lead to a loss of subscribers and sponsorships and lots of the monetization. See, for example, Illuminati. Sometimes you can turn a very little, teensy little spat that could have blown over in, it's like a fart in the wind sometimes. You look at Sunny V2. In my opinion, Sunny V2 is kind of awful. But when he was exposed as being awful, he never commented on it. He never fought about it. He just went about business as usual, and he hasn't suffered. But you look at Illuminati. She, for those of you who haven't followed, I'm sure all of you have because it's taken over YouTube. Like I said, I might cover the lawsuit. Send me the documents if you want me to, unredacted. But she accused Legal Eagle of plagiarism falsely. It was nonsense. And people called her out for it. And her fellow, former coworkers called her out for being awful. Instead of ignoring it, letting it blow over, that whole thing could have been a fart in the wind. Instead, she decided to hotbox everyone with the most rancid farts you could imagine, and she's suffered. She's lost 500,000 subscribers almost, and her views have gone from like 1 million per video to 20,000. You pick fights, you act as a bully, you hotbox everyone with your rancid farts, you're going to have a bad time on the internet. And that's going to be the case for Lauren the Mortician and Attorney Braun. This isn't a good look. Of these sponsorship deals, Ms. Propson was sponsored in a brand partnership with a famous documentary channel. So, this is a good time to remind everyone, because I know my regular viewers are sick of seeing this. But this is a new case. So when I start a new case, I like to wipe the slate clean and act as if I haven't explained something 1 million times before. Because new case means new people. And I want to explain things for the new people. So, existing viewers, bear with me. Excuse me. So, it's a good time, I think, to discuss the federal rules of civil procedure, and specifically Rule 8, the general rules of pleading. And specifically, we're looking at Rule 8A, claim for relief. A pleading that states a claim for relief must contain three things. One, a short and plain statement of the grounds for the court's jurisdiction, unless the court already has jurisdiction and the claim needs no new jurisdictional support. So we've already discussed point one, because the grounds for the court's jurisdiction, that's diversity jurisdiction. And unless the court already has jurisdiction and the claim needs no new jurisdictional support. So that would be, it's a constitutional claim. It's based on federal law. It's it's a tax case. It's a federal securities case. It's federal criminal, although the federal rules of civil procedure then wouldn't apply. But either way. So number two, a short and plain statement of the claim showing that the pleader is entitled to relief, and a demand for the relief sought, which may include relief in the alternative or different types of relief. So I think in regards to number two, a short and plain statement of the claim showing that the pleader is entitled to relief. So we need to look at Rule 12 as well. So this is defenses, objections, when and how presented, motion for judgment on the pleadings, consolidated motions, waiving defenses, pretrial hearing. Now, you're going to hear me talk a lot about 12b-6. So 12b, how to present defense. Every defense to a claim for relief in any pleading must be asserted in the responsive pleading if one is required. But a party may assert the following defenses by motion. So 12b-1, motion to dismiss for lack of subject matter jurisdiction, which we very well may see depending on what Attorney Braun's actual domicile is, where she lives the other part of the time. That could very well lead to lack of subject matter jurisdiction, lack of diversity. So 12b-2, lack of personal jurisdiction. 12b-3, improper venue. The venue's proper based on the location of Braun IP Law, the law firm. 12b-4, insufficient process. So that would be like, for those of you who have followed the Illuminati saga, one of the defendants, Felix the Kit Kat. Now, this is Colorado State Court, not federal, but Felix the Kit Kat has posted on Twitter, I think, saying, Illuminati is suing me, and she's trying to get me in a default judgment, but I haven't even been served because apparently she served someone at a house I haven't lived in for 8 years. But they swore that they served me there. So Felix the Kit Kat in the Illuminati lawsuit would be bringing the Colorado State civil procedure rule equivalent of a 12b-4 motion to dismiss for insufficient process. Well, no, sorry. It would be 12b-5, insufficient service of process. Mostly the same thing. So, but the big one that we're after is 12b-6, failure to state a claim upon which relief can be granted. So we're not going to discuss Twombly and Iqbal today. We will on the motion to dismiss when it eventually comes in. But basically, 12b-6 is saying, look, judge, according to Rule 8, the plaintiff needed to bring a short and plain statement of the facts that would entitle them to relief. But I don't think those facts are enough to state a claim upon which you can grant relief. Now, Twombly and Iqbal, two Supreme Court cases from about 2007 and 2009, I believe, they set the standard, they're the gold standard for 12b-6 and Rule 8. And basically it says you can't, conclusory statements aren't good enough. Saying they defamed me, that's not good enough. You have to bring facts about what they said and how that is defaming you. Now, why am I mentioning this now? Well, because I just, of these sponsorship deals, Ms. Propson was sponsored in a brand partnership with a famous documentary channel. That is so vague that I have a hard time seeing it passing 12b-6 muster. It's not conclusory, and conclusory meaning basically stating your claim or stating your opinion. It's in previous videos I've talked about the South Park underpants gnomes. Step 1, underpants. Step 2, question mark. Step 3, profit. This is the equivalent of 1 and 3, with 2 just being the question mark. So it's 1, I was defamed. How were you defamed? And then 3, profit. So moving on. Defendant KC is a social media personality publicly known as Caffinated Kitti. Defendant KC describes herself as a villain life coach. That's brilliant. On or around October 24th, 2023, Defendant KC published a video of herself to TikTok where she made statements about Ms. Propson and identified her by public persona Lauren the Mortician. In the October 24th, 2023 video, Defendant KC accused Ms. Propson of being transphobic and a TERF because she liked posts by a conservative social media personality who is in a gay relationship. TERF is a derogatory slur in feminist groups and a highly offensive term. TERF is an acronym standing for Trans Exclusionary Radical Feminist, which is a term used to refer to or describe an advocate of radical feminism who does not believe that transgender people's gender identities are legitimate, and who is hostile to the inclusion of trans women in the feminist movement. Dictionary.com, TERF definition, accessed on December 12th, 2023 from dictionary.com. So now, some people would argue, hey, being a TERF is a good thing. Those darn transsexuals, I hate them so much. And that's going to be clipped probably and not look good. But you look at J.K. Rowling. She's credibly, I think, been accused of being a TERF, and she's, I think, embraced it. And despite protests and despite not looking so great, despite protests, the recent release, last year, recent, of the Harry Potter video game was radically successful. It certainly hasn't appeared to harm J.K. Rowling's pocketbook. It's now I don't know Lauren the Mortician. I have never watched her videos. I don't know her politics, her likes and dislikes and prejudices or non-prejudices or whatever. Same with all of the defendants as well. I have only heard of them through Markey and this case. So I don't know. Lots of people, when they're found out as a TERF, they pivot into, right-wing politics, manosphere, anti-trans, whatever, and they find themselves highly successful doing that. So it's like, if you accused me of being a TERF, I'd be offended, but I don't know that I don't know that even the majority of society would be. And I'm not a politics channel. I try to avoid politics, but I'm just going to say I have never found that I harm relationships, I hurt people's feelings. I have never found giving love and kindness to anyone to be detrimental to myself. Whether I like them or not, whether I agree with them or not, whether they live like I would or not, I have never found being kind to lead to bad situations for me. So I'm just going to say, hey, be kind. That's generally the best policy, I think. And I do not know which conservative social media personality in a gay relationship it was that she reposted. And I'm kind of thinking it's that Milo guy that was, kind of big 7 years ago. But I have no idea. That's just the only one I can think of, because people in gay relationships don't tend to be super accepted in conservative media circles. So the below images are screenshots from the October 24th, 2023 video post where defendant Casey accuses Ms. Propson of being a TERF and transphobic. And here we have Caffinated Kitti on TikTok, and it's captioned, "Lauren the Mortician is a TERF. Bi people can be transphobic. Unfriendly reminder, we see transphobic, so we're saying transphobic. That ain't bullying, it's an astute observation." Boondocks 2014. So right there, that shows that this is opinion. We see what we interpret as being transphobic, so we call it transphobic. So whether it was transphobic or not, this is her interpretation. That's opinion, and opinion is protected and not defamation. And we should also mention, now we're at 24. Scrolling back up, we'll see this later as well, but this is for defamation per se, trade libel, false light, intentional infliction of emotional distress, and tortious interference with business interests. So defamation per se is a little different than standard defamation, in that there are certain types of things that are defamation per se. And so accusing someone of being unchaste, saying, "You're a whore, you sleep around with everyone you see," that, if it's untrue, would be defamation per se. Saying, "You've got STDs because," that would be defamation per se if it's untrue. Saying, "You're a thief," because that's a crime of moral turpitude, that would be defamation per se. And a few other things. It's limited. So from what I've seen, well, they might be claiming defamation per se as the criticisms of Attorney Braun's business practices, but calling someone a TERF, I don't think that counts as defamation per se. But either way, for defamation, we have the higher standard if someone is a public figure. And Lauren the Mortician, with millions of TikTok followers, probably is a public figure. So she's going to have to prove actual malice, which is the knowledge of the falsity or a reckless disregard for the truth. And so that's a really high standard, really high. And whereas in standard defamation, you might win just proving that it's false, whether the defendant knew it was false or not. It doesn't take the reckless disregard for the truth. Now, they're going to be arguing some stuff kind of about reckless disregard, like they're not, they didn't ask about, they didn't contact the plaintiff to ask, they didn't interview them, they didn't thoroughly research it. But I don't think that's going to matter. And it appears to me that Attorney Braun might also be a public figure, because it seems that she is also active on TikTok or YouTube or something. But once again, I haven't looked into it too much yet, but it appears to me that she has. So either way, even if Lauren the Mortician is able to show, look, I'm not a TERF. I have, like, half my friends are transsexual, and I'm dating someone who is, and blah blah blah, whatever. You don't have to research that. Caffinated Kitti saying, based on this post, my opinion is that she appears to be a TERF. That's protected speech that doesn't nearly reach the level of reckless reckless disregard for the truth, plus its opinion. So, and that was from October 24th, 2023 on TikTok by Caffinated Kitti. In explaining her reasoning for her accusations, defendant Casey stated that she was not accusing Ms. Propson of being transphobic because Ms. Propson has a larger fan base and following, but because people were confusing Ms. Propson's Laura the Mortician persona with defendant Casey's Caffinated Kitti persona. And we have on the TikTok the caption saying, the only reason I'm saying anything about it is because I'm getting confused for her. But once again, if she has that opinion and would have kept it to herself, but for them getting confused, her motivations in doing it are irrelevant if it's opinion. Along with the video, defendant Casey announced that she compiled a list of links to posts that Ms. Propson liked containing transphobic and hateful rhetoric. And this is a post by Conservative Ant, who I've never heard of, who has 315,000 Twitter followers. I think that is this Twitter or Instagram? Blue check mark. I think this is Twitter. I could be wrong. I haven't used Twitter in a long time and only did for a very short time. But Anthony Raimondi, public figure, political commentary, SWFL strong. Don't know what that means. Free thinker. This is my only Instagram account. So there's the answer to that question. I don't really use Instagram either. And this is Caffinated Kitti's TikTok saying transphobic and hateful rhetoric and content. And then her Instagram post saying, I'm not one for drama, but when I'm getting confused for someone, it becomes my business. And I value being thorough when it comes to addressing any accusation against someone else. Is it too much to ask that people hate me for who I am instead of being mistaken for Lauren the Mortician and being hated for that? Anyway, take my information and do your own research if you'd like. But refusing to address why hateful content is so likable smells like cowardice to me. I will post my link list in the comments for y'all, but do not comment on this guy's derogatory stuff. It's rage bait for a reason. And then hashtags live your truth, hashtag Lauren the Mortician, hashtag Beetlejuice, hashtag drama, hashtag gotta love it, hashtag receipts, hashtag transphobia, and hashtag transphobic, hashtag accusation, hashtag beef Wellington. Okay. Hashtag controversy, hashtag cancel culture, hashtag women, hashtag men, hashtag non-binary, hashtag be villain, hashtag caffeinated kitty, and then VD Kitty. Oh, visual description. Kitty with her purple hair pulled back, speaking in her car, with a black button up dotted with golden stars. Occasionally, she shows a screen recording behind her of a list of URLs that lead to transphobic content on an Instagram page and the flag that Lauren the Mortician's verified account likes the content. So this to me doesn't look like a reckless disregard for the truth. It It may be the wrong interpretation of the actual facts, but it looks like she did her research the best she could and said, hey, based on this list of posts that she has liked, my conclusion, my opinion is she's transphobic. And that is not defamation. It may hurt her feelings. It may make her look bad. It may make Lauren the Mortician look bad. But it's not defamation. So, upon information and belief, none of the videos defendant Casey linked contain transphobic and hateful rhetoric. That's conclusory. That's conclusory. Now, I'm not going to call like there for those of you who follow my work with covering delete laws, I call him Captain Conclusory. Now, there, this isn't enough, at least not yet, to get onto that train and be Corporal Conclusory, or someone suggested Commodore Conclusory. I like that. We can have Colonel Conclusory, but I don't think that this, at least not yet, is enough for the conclusory armed forces. But this is conclusory. It's just, well, none of the videos, none of the links contained transphobic and hateful rhetoric. Show us the links. Show us what is said. You just saying it wasn't transphobic, but there's also no links here, so you've just got to believe us, it wasn't transphobic. That is nothing. That is worthless. It's worthless. This is a terrible complaint. Besides which, it's opinion. It's opinion. What? Well, the links she shared weren't transphobic. According to who? According to you? You don't find them transphobic? But if Caffinated Kitti finds them transphobic, but we can't determine that because this is a conclusory statement. It gives us no information. Does anyone smell a 12B6 coming? Choo choo. 12B6 on the way. It's on the tracks. Upon information and belief, defendant Casey's motive and intent behind these posts were to tarnish and damage Ms. Propson's reputation. Due to Ms. Propson's following and fame, the allegation that she is transphobic spread quickly throughout the internet and became the source of multiple posts, comments, and blog articles. Now, once again, suing, going full Illuminati is not the way to make those allegations disappear. This is a good time to discuss the Streisand effect. If she hadn't sued, I wouldn't be making this video. Now, I realize I don't have the reach that she does. But Marky has a long reach. Let's see. 1 day ago, 106,000 views. 3 days ago, 136,000 views. 9 days ago, 151,000 views. 11 days ago, 186,000 views. 2 weeks ago, 197,000 views. And his first video on her 3 weeks ago, 378,000 views. She could have done the Sunny V2. Ignore it. Let it continue as usual and let it flutter away like a fart in the wind. Instead, Marky has over 1 million views discussing it. Ian Runkle, who covered it, has 38,000 views. Mad Catster, another YouTube attorney, 13,000 views. So people are covering it. I'm guessing he hasn't yet, as far as I know. Of course, he might have on Twitch already. But you know, it took him until 2 days ago to talk about Illuminati. But let's see. I don't see anything from Moist Critical yet. I 100% believe that this is something Charlie is going to cover at some point. And it will get 2 or 3 million views. And she's going to have a bad time. Let's see. Atozi, I don't think he has yet either, but he's very similar in content to Marky, but with 1 million more subscribers. And I don't see anything there yet, but I 100% believe Atozi will cover this. Many more will cover it. Now, Caffinated Kitti and the others, I wouldn't recommend they cover it during the litigation. My general philosophy is fundraise if you need to, because lawyers are expensive, but shut the fuck up. Just like if you're facing criminal charges, Fifth Amendment, shut the fuck up and let your attorney handle it. You don't have a Fifth Amendment in civil litigation, but you should still STFU and let your attorney handle it. Talk about it all you want once you win. You know, look at Natalie Lawyer Chick. In her time on YouTube, she's been sued twice by idiots, in my opinion. Her acquaintance who sued her for defamation, the first lawsuit, we didn't even hear about it until it was over. When the kitchenista sued her and the Hollands and Darius Crooks, and, we didn't hear about it from Natalie until Natalie had won. The Hollands and Darius Crooks had not won yet. She discussed it again when the Hollands won, but we didn't hear about the kitchenista suing her, at least not from Natalie, until she won. The kitchenista probably was talking about it on her pages, but I don't follow her social media, so I couldn't say. So the point is, upon information and belief, defendant Casey's motive and intent behind these posts were to tarnish and damage Ms. Propson's reputation. This lawsuit has done more to tarnish Propson's reputation than anything Casey said, true or not. Bringing what appear to be bad faith lawsuits against fellow YouTubers or fellow content creators, that's the quickest way to get your channel dead, to lose your following. Filing a false copyright strike is one of the absolute worst things you can do. Even a legitimate copyright strike is people are going to criticize you for it. Speaking of apparently false copyright strikes, we'll get to that. But suing fellow content creators is frowned on even more, whether you have a case or not. But in this case, this is the ultimate sin. Tell me in the comments who has an album, The Ultimate Sin. Due to Ms. Propson's following and fame, the allegation that she is transphobic spread quickly throughout the internet and became the source of multiple posts, comments, and blog articles. And I realize now that I had already read that, but either way, it spread to a lot more because of her actions. The impact of this allegation caused Ms. Propson immediate and irreparable harm to her reputation. Specifically, Ms. Propson lost numerous followers, her contract with a famous and popular documentary channel, and a podcast deal that was in negotiations. It's so vague. She lost numerous followers. How many? Tell us. Say, as of the filing of this complaint, she has lost 500,000 subscribers. Numerous followers. Okay. And once again, a famous and popular documentary channel, vague. You're not articulating facts. Is it the Discovery Channel? Is it PBS? Is it a YouTube documentarian? I realize there are some very good ones out there, but what is it? Defamatory statements against Jeanette Braun and Braun Law by defendant Casey, professionally known as Caffinated Kitti. Along with the video, defendant Casey used screenshots of comments that were authored by Ms. Propson to engage with her fans. These comments included original opinions and thoughts that did not relate to or support the allegations that Ms. Propson was transphobic. Ms. Propson hired attorney Jeanette Braun to assist with her copyright infringement claims by filing a Digital Millennium Copyright Act, DMCA, complaint to the social media platforms hosting the video. Attorney Braun filed a DMCA complaint to the social media company Meta regarding the use of copyrighted material on defendant Casey's post on Facebook that copied Ms. Propson's copyright protectable material. The DMCA complaint and request for removal of the content was limited to just the post identified. Following the DMCA complaint being filed, the platform agreed with Ms. Propson's claim and approved the DMCA removal request. On November 4th, 2023, Meta removed defendant Casey's post that copied her copyrighted material. Upon information and belief, on or around November 4th, 2023, defendant Casey's entire Facebook account was locked by Meta, and defendant Casey could not access it. On or around November 4th, 2023 to November 5th, 2023, in TikTok story posts following Meta locking defendant Casey's account, defendant Casey posted various videos where she appeared irrational and engaging in erratic behavior, such as threatening people online through various social media platforms. A TikTok story post is a brief video on the platform that remains visible for 24 hours or until the user decides to delete it. And typically, once the 24 hours expires, the post is not reposted or republished. The plaintiffs were concerned about defendant Casey's mental health and safety, which prompted them to call a wellness check to defendant Casey's local non-emergency hotline. I mentioned when we were looking at Marky's videos on the subject that we will discuss those phone calls in probably the next video on this subject, which will probably come sometime after Christmas. The phone calls were not good. They appeared to me to be an attempted swatting. Now, Attorney Braun, that is my opinion. If you sue me for it, you are going to have a bad time. Same with you, Lauren the Mortician. It's my opinion. But calling in, even to the non-emergency number, and saying someone is irrational, someone is acting irrational, and they're threatening people, and I'm concerned for their mental health, and blah, 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 that leads to police encounters that could lead to bad consequences. Let's put it that way. It's swatting. That's what it looks like to me. And when we listen to the video in a future video, we're going to hear Attorney Braun trying to bolster her claim by, I am a federal licensed attorney, or I'm a federal attorney, and blah, blah, blah. Therefore, give more weight to my statement. First of all, I don't know what a federal attorney is. And like the qualifications to practice in federal court is you have to be licensed to practice before the top court in a state, to the highest state court. So, and then you have to pay a fee to the federal courts and take a class on how to use ECF and PACER, and you have to be sworn in to the federal court. That's all it takes. As long as you're a licensed attorney, that's all it takes. It's not something to brag about. Now, bragging about being licensed by the Supreme Court, that's a little bit more impressive, but still, basically, they have whole sessions basically in the Supreme Court where someone who is licensed in the Supreme Court will go in and they'll say, "This is my friend Joe. He is a licensed attorney. I nominate him to be granted access to practice in the Supreme Court." And the Supreme Court justices will say, "Yo, Joe, you're good. Raise your hand and take the oath, and you're good." That's basically what that takes. So not everyone who's licensed by the Supreme Court has argued in the Supreme Court. But the moral of the story, though, is her saying I'm a federal licensed attorney. Whoop-de-doo. Do you want a cake? And the wellness checks to the local non-emergency hotline were bullshit. They were an attempt. Like, to me, at a minimum, it was an attempt to harass KC, Caffinated Kitti, through law enforcement. At worst, it was a swatting attempt, attempting to cause her physical harm through law enforcement. It was a terrible move. Not good. Defendant KC used her social media accounts to express her anger and resentment of plaintiff Jeanette Braun and her law firm. No shit. You swat her and then you're shocked that she used her social media accounts to express anger and resentment about it? Are you delusional? Do we need to call a mental health check on you, Jeanette Braun? Because you don't realize that doing this will cause resentment? Are you that devoid of human feeling? Like, I realize I'm a cyborg. I've got a robot leg. I know human emotion. Do you? Jesus. On or about November 13th, 2023, counsel for defendant KC contacted attorney Braun to engage in a discussion about the copyright infringement report and were in settlement discussions. On or about November 21st, 2023, while settlement discussions were still ongoing, defendant KC posted a video accusing Ms. Propson of using attorney Braun to file bad faith copyright claims with social media platforms. And like I said, I've only seen what Markey has played and discussed. Before the lawsuit was filed, I was thinking about reviewing them and giving my opinion on whether they were legitimate copyright claims or if they were bad faith. So we have a screenshot of the video saying, "In bad faith copyright infringement strikes." In the same video, defendant Casey accused attorney Braun of filing bad faith copyright infringement strikes against defendant Casey. Now, here's the thing. If they were in bad faith, both of you were in bad faith, but the attorney's bad faith is of a higher level because the attorney should know better. Once again, I haven't seen them. I don't know for certain they were bad faith. From the limited amount I have seen, I'm going to go out on a limb and say there were at least some bad faith copyright infringement, copyright strikes. At least some. You can't sue me for that, or, well, you can, but you'll have a bad time. It is my opinion. It is based on the limited amount I have seen, but from that limited amount, it would appear that it's fishy. As of the filing of this complaint, the video identified above was viewed approximately 928,000 times. It'd be nice if this video got 928,000 views. On November 25th, 2023, defendant Casey posted the same video again on TikTok. As of December 14th, 2023, the second posting has received over 263,000 views and published it through this link, with the TikTok link. And it says on the video, reposting the tea since a lot of people are claiming they can't see the original anymore. And then the video description, so strange. Some are still able to engage. Some are getting notifications about their comments being liked, but can, and then more. They would have been nice if they had expanded that. And her comment, oh, and for those on this new version, if you go to the fund, you can find the first annotated page of Jeanette's letter to me. And I believe this is referring to her GoFundMe and the letter from Jeanette to Caffinated Kitti, which Jeanette Braun seems to be upset that the letter was posted, but that there's no reason for her not to post it. That, like, she literally does not owe you a duty to not post it. It's not defamation posting it. It's not, trade disparagement, that all that nonsense. It's nothing. It's legal. Now, it's not violating Lauren the Mortician's attorney-client privilege, because that privilege doesn't bind Caffinated Kitti. Now, the reason Jeanette Braun could find herself having a very bad time is because by suing with Lauren the Mortician as a co-plaintiff, that attorney-client privilege as to any of her interactions, but especially the copyright stuff, that attorney-client privilege is probably going to be breached because they're going to need it for discovery in this case. And if there aren't ironclad waivers, conflict waivers, attorney-client privilege waivers that have been signed by Lauren the Mortician, and with her represented by independent counsel when she did it, your license could be on the line for it. Like, this is mega serious. It is bad. Every lawyer who looks at this, like, did you pass the professional ethics MPRE? Is your license actually valid? Like, These are serious concerns. This is not good. And yet, you know, Caffinated Kitti posting the letter from the attorney. Well, that's bad. We've got to sue her. Upon information and belief, defendant KC receives compensation from TikTok based on the number of views and a video receives, and thus is profiting from their posts that spread the false statements about Attorney Braun and Ms. Propson that are described in this complaint. That's irrelevant. You're allowed to profit off of your posts, even if they're posts about other people. You're allowed to profit. Now, I'm making this video about Caffinated Kitti and Jeanette Braun and Lauren Probson and the others whose names I can't remember yet because we haven't reached them in the complaint other than the caption and stuff. But I'm going to make some money off of it. Admittedly, not nearly as much as the subjects of this video. My opinion of Jeanette Braun and Lauren the Mortician is subterranean. It is low, my opinion of them. I think they are terrible from what I have seen. But I can profit off of that. There is nothing wrong with that. Now, I think the reason she's doing this is if she wins, they'll argue it forms some form of the basis for the amount they should receive, but that's not how it works. It's not, you received this much money for defaming me, therefore I should receive that. But that's backwards. It's, I lost this much money because you defamed me, therefore I should be made whole in the amount I lost or could have lost, and punitive damages and whatever. But you made this much money from defaming me. That's not one of the elements of defamation. Defamation is, what did you lose? What harm did you suffer? Caffinated Kitti making money isn't harming you. It's the video itself that allegedly harmed you, not her profit from it. So I realize, we see this, but it's irrelevant. And, even Schofield versus Giard, the TikTok psychic case, Professor Schofield had, in her complaint, the TikTok psychic Giard posted over 100 TikTok videos for internet clout, profit, blah, blah, blah. Her purpose really was irrelevant. But then Schofield or Giard tried to counter sue, and it was terrible. But one of her big complaints is, she lied about me because she said I made money off of it, and that's false, and so that's defamation. And it's like, well, number one, what harm has that caused you? It's not defamation because it's within litigation. But you not being monetized doesn't mean that's the only way you were trying to profit off of it. You were trying to drum up business. You were trying to build clout to get new clients. That's how you profited. But it's still irrelevant. So upon information and belief, on or around November 21st, 2023, defendant Casey created a page on the donation platform called GoFundMe. And once again, this is irrelevant. It's irrelevant. It just shows, hey, I'm facing legal troubles. I need help defending myself. That doesn't have any impact. It's just absolute nonsense. On the GoFundMe page, defendant Casey revealed Attorney Braun's name and identity by posting a portion of Attorney Braun's cease and desist letter. Who cares? Your name is not defaming you. Are you trying to say you were doxxed? It's public. You sent her the letter. What she does with that letter is up to her. It's not illegal. It's not defamation. It's not harassment. It's common. It's fine. On or around December 8th, 2023, defendant Casey published her email response to Attorney Braun and falsely claiming that Attorney Braun filed a false copyright claim and that she was a fan of Lauren the Mortician that was not actually retained to be Ms. Propson's attorney. From what we've seen, she is her attorney. I think the reason she's doing this is she's trying to say, look, she's targeting my business ethics by saying, but once again, she doesn't know there have been false copyright claims by non-attorneys or by non-retained attorneys, and they're yeah. I mean, there's an attorney, I believe, in Texas that, if you get a false copyright strike, and don't want to provide your name, you pay him $30 and he'll send the counter notification to YouTube and use his address and email address and stuff. And it's like, have you retained him? No. You've just paid for that one little service. It's either way. This is pretty weak. And upon information and belief, defendant Casey knowingly published these statements after learning that Attorney Braun was in fact retained by Ms. Propson. The below screenshot is an accurate copy of the GoFundMe page. And it's titled, Kitty is a spiteful, see you next Tuesday. And it says, y'all know what this is here for. So the body of the GoFundMe didn't have a whole lot, but the updates, December 8th, 2023, by Kitty Laloon, organizer. The email I sent in response to the copyright claim, reminder that my following post indicated I was ensuring I was legally doing what was correct before whistleblowing. Also, according to her call to the police, Jeanette wants to report this to the FBI. My reading of this is coming soon. It reads, subject line, false copyright claim, sent 1:40 p.m. on 11/4/2023. Good afternoon, Jeanette. So this is the letter she sent to Attorney Braun. I've reached out to the owner of the video you had taken down for copyright and she confirmed that she did not have any issue with my reposting of her content, as I explicitly asked for her permission beforehand and still maintain it. So, if at that time she had reached out to the content creator and they said, yeah, it's fine, that would give you the impression that it's a rogue fan or attorney or whatever. Like, whether she was right or wrong, this appears, at least based on her email, this appears to be a fairly logical conclusion. My team and I would love further details on your client and how the video had grounds for a copyright strike, as it clearly falls under fair use. And in parentheses, under the fair use doctrine of the U.S. copyright statute, it is permissible to use limited portions of a work, including quotes, for purposes such as commentary, criticism, news reporting, and scholarly reports. There are no legal rules permitting the use of a specific number of words, a certain number of musical notes, or percentage of a work. Whether a particular use qualifies as fair use depends on all the circumstances. See Fair Use Index and Circular 21, reproductions of copyrighted works by educators and librarians, if you need a refresher. So, from my understanding, Attorney Braun tried to, appeal to authority, basically, and how dare you try to tell me about fair use? I'm an attorney, a federal attorney. I know what fair use is, and you couldn't possibly know. But you're wrong, and I'm right, 'cause I'm an attorney. So you better not question me, or fight back, or defend yourself, or I'll sue. That's what it looks like. I do understand how you have reached out with cease and desists to smaller content creators speaking negatively about Lauren the Mortician's scandals. And while I understand your desire to protect a creator you enjoy, if you were not legally obtained as counsel for her, and I speak on this via my platform, your actions are going to cause her significantly more strife. I would imagine it would reflect very negatively on you and your practice, as well as well for you to attempt to use your personal law firm to intimidate people because you don't like what they have to say. You should patch me in with your business development and PR team. I'm sure they'd have some interesting advice for you. I look forward to your response. Kitty. Now, I noticed something in there. I don't think Attorney Braun is going to appreciate my noticing this. But this entirely contradicts her claim. It contradicts her claim. This is bad news for Attorney Jeanette Braun. Because let's scroll back up. On or about December 8th, 2023, defendant Casey published her email response to Attorney Braun and falsely claiming that Attorney Braun filed a false copyright claim and that she was a fan of Lauren the Mortician that was not actually retained to be Ms. Propson's attorney. So her allegation here is that Casey affirmatively stated, you filed a false copyright claim and you are a deranged fan who doesn't actually represent Lauren the Mortician. You're just doing this because you're a fan. But I didn't see that in the letter. I didn't see that in the response email. While I understand your desire to protect a creator you enjoy, if you were not legally obtained as counsel for her, your actions are going to cause her significantly more strife. If it doesn't say since you were not hired by her, retained by her, because you are not retained by her. I know you are not retained by her. I am alleging you are not retained by her. No, it says if you were not legally obtained as her counsel, your actions are going to cause her significantly more strife. If if that one word there, and well, I mean the entire phrasing of that entire email, but that one word especially, if, that blows up this claim. It's complete nonsense. And it's captioned Kitty Laloon. Kitty is a spiteful see you next Tuesday. And you all know what see you next Tuesday stands for. Defamatory statements made by Rebecca Day. Nay, box. Defendant Day is a social media content creator known as Bekah Day, who holds herself out to be an unbiased content creator and an independent investigative reporter. Upon information and belief, Defendant Day has no professional training or degree in journalism. That's irrelevant. And guess what? A journalist is not a licensed profession. You don't need a degree. You don't need professional training. You don't need anything. I have no professional training as a journalist. I have no professional training in broadcasting, as you can plainly see. I have a bachelor's degree in finance. I have a master's degree in international banking and finance. I have a Juris Doctorate, a law degree. I am here acting as an educational opinion broadcaster, journalist. I didn't need professional training. It doesn't give more or less weight to the things I say. It's, you know, it basically the professional training or degree in journalism that, you know, in the old days, that was a lot more useful because there were limited options. You had to get hired by your radio station or a newspaper or whatever, TV station. Now any idiot with a computer can get online and do it. And if they're good, they'll get an audience. Does Lauren the Mortician have a professional degree or training in journalism? I didn't think so. Upon information and belief, the below screenshot is an accurate copy of Defendant Day's LinkedIn profile as of the filing of this complaint. And its header, Stand for Justice. Bekah Day, over 700,000 connections made on TikTok. And her job on TikTok. Content creator, TikTok, self-employed, Kansas City, Missouri, United States. 3 years. Okay. Upon information and belief, Defendant Day creates content that disparages public figures and other celebrities that she monetizes for income from TikTok. Once again, irrelevant. Upon information and belief, Defendant Day receives compensation from TikTok based on the number of views a video receives, and thus is profiting from her posts that spread the false statements about Attorney Braun and Ms. Propson that are described in this complaint. During her social media career, Ms. Day has been accused of posting false and untrue statements about public figures, such as Grammy Award-winning musician Diplo and other prominent social media personalities. Let's look at the federal rules of evidence. Now, the federal rules of evidence don't really apply to the complaint. It's for trial, mainly. But let's look at Rule 404, character evidence. Evidence of a person's character or character trait is not admissible to prove that on a particular occasion the person acted in accordance with the character or trait. And B, other crimes, wrongs, or acts. Evidence of any other crime, wrong, or act is not admissible to prove a person's character in order to show that on a particular occasion the person acted in accordance with the character. So, why do I bring that up? It's because that's the only reason they brought this in. It's completely irrelevant. It cannot be considered for anything in this lawsuit. This is just trying to show, look, she has a propensity to defame other people, other celebrities. Therefore, what she's done to my client is defamation. But that's inadmissible. That will never get before a jury, ever. So we can only consider what she has allegedly done to your client or to you, to the plaintiffs in this case. What she has allegedly done to Diplo is irrelevant. It's inadmissible. It's just trying to poison the court against her, and frankly, the court can't consider it. But let's say she did actually defame Diplo. That adds nothing to whether or not what she said about you and your client were defamation. This does nothing to bolster the falsity that you claim she has spread about the plaintiffs. This is a red herring. This is nonsense. It's ridiculous. So we have a post from Diplo. Hi, Bekah. Would you like to discuss your recent post about my biography? A lot of it is untrue, and I'm not sure if you know this, but Shelley has been proven a liar at every time, and the second allegation of the R word was fraud, false, whatever. So we can't see the whole thing because someone's talking over it. And then, dear Mr. blank re de Bekah. Please be advised that I represent Dr. Kenny Wilstead and Smile Again Delta Dental LLC. Very recently, it has come to my attention that a woman who identifies herself as Bekah Day is blasting my clients on TikTok unrelentingly and with no regard for the truth or falsity of her statements. Although some of her points may have some merit, many are blatantly false and are causing a significant loss. At this time, I am asking that you and she cease and desist from making any further defamatory statements and from tortiously interfering with the contractual relationships and the business relationships between Dr. Wilstead and his patients, employees, and others. And then can't read that whole next paragraph. Either way, it just, once again, it doesn't matter. It's irrelevant. It's inadmissible. Now, if Ms. Day is spreading lies about anyone, I'm not her attorney. I never will be her attorney. This is not legal advice. It is just a friendly reminder. Don't be a dick. If you have information, share it. If you're making stuff up or you know something is false, don't. If it's a questionable case, you should probably, share your source and say, so yeah, this, I don't know if it's true, but so-and-so is saying it is. But it might not be. That's probably a better way to do it. I don't know how you do it, but because I don't watch you, like I said, this is what I know you from, is this lawsuit. In November 2023, Defendant Day made content regarding Defendant Casey's claims about Ms. Probson and Attorney Braun. Upon information and belief, Defendant Day did not conduct any investigation that involved fact-checking or reaching out to knowledgeable parties to verify the information in her posts. Defendant Day never contacted the plaintiffs to verify the information in her posts. Defendant Day created and posted videos stating the false claim that Attorney Braun files false copyright strikes and is unethical and is a rogue attorney, some of which are shown below. And this is titled Attorney Braun Files False Copyright Strikes. And Bekah Day replied to your comment, I posted proof on my page that your legal name is attached to the false copyright strikes. Don't know why you're behaving like this on the internet. And I can't read what's above that, but no one can mass report a video for copyright infringement. Then, next post, Attorney Braun is unethical and files false copyright strikes. And because they were allegedly involved in Dempsey's snart group, is that a sneeze fart? Bekah Day, there are a group of creators on this app who have weaponized Jeanette's aggressive, threatening, and unethical tactic to scare creators off the app. I have a list of creators who have utilized Jeanette and another list of creators who have been wrongfully impacted by false copyright strikes sent in by Jeanette. This is just the beginning. Shocked and applauded, I think she means appalled, to see women in mutuals with, hiring this woman to do their dirty work. 'Tis the season of exposing, I suppose. And then hashtag trending, hashtag exposed, hashtag viral, hashtag influencer, hashtag drama TikTok, hashtag T-Talk, hashtag famous, hashtag shocking, hashtag fame, hashtag damps. And that's Attorney Braun is a rogue attorney. So guess what? You don't like, you don't have to share your sources. You don't, she's saying, hey, I know of people who have been struck. I don't believe they're legitimate. You don't have to conduct an exhaustive investigation. Now, some of them might not have been. Some of them might have been. I don't know. Either way, I think she's going to have a hard time here. Especially, you know, people saying Jeanette Braun filed a false copyright strike on Caffinated Kitti for Lauren the Mortician. If Day had said that, or if she had said, Caffinated Kitti believes she has suffered a false copyright strike by Braun and what's her name? Lauren the Mortician. And from what I have seen, that appears to be the case. That wouldn't be defamation. Not even close. In a since deleted video from TikTok, Defendant Day stated her intent to ruin Attorney Braun's career as a social media lawyer. And the quote, "But I just wanted to make it very clear that my position is to ensure that there is not a rogue attorney on this app." And that's titled Harassment Campaign Against Former Client. Or, yeah. Either way, that's not defamation. That's her stating her mission, stating what she wants to do. Like, that's way too vague to be defamation anyway. It's what I want to make clear is that my position is to ensure there is not a rogue attorney on this app. Is that calling Jeanette Braun a rogue attorney? Is it saying, or is it saying, my mission is to investigate whether or not you're a rogue attorney to make sure there isn't a rogue attorney on this app? My mission is to clear you, to clear your name, to ensure there isn't a rogue attorney on this app. Any of those could be an interpretation of that statement. It's too vague to be defamation. This is ridiculous. So, harassment campaign against former clients. Upon information and belief, Defendant Day is using the above false statements to incite an angry mob and harassment campaign against Attorney Braun's past clients that are social media influencers. Defendant Day's harassment campaign has had detrimental effects on Attorney Braun's former clients and caused emotional distress and harm. But guess what? Guess what? That's irrelevant. Harassment and causing detrimental effects to the former clients and causing them emotional distress and harm, guess what that's not? It's not causing you emotional distress and harm. This is not a claim you can make. It's a claim your former clients would have to make for themselves. I don't see their names in the plaintiff caption. I don't see Dempsey in the plaintiff caption. So any harm caused to Dempsey is irrelevant, completely irrelevant. It does not matter. Remember we looked at Rule 8 of the Federal Rules of Civil Procedure. A short and plain statement of the allegations and blah, blah, blah. This is 40 pages. This is not a short and plain statement. Adding in irrelevant things and things that would never be admissible is not a short and plain statement. This is bad lawyering. Now, it wouldn't be Jeanette Braun suing me. It would be her attorney because, you know the saying, an attorney who represents herself has a fool for a client. Well, I still believe she is a fool, but I also believe she has a fool attorney because she has retained counsel. But the retained counsel, would have a bad time suing me for saying I believe he is a poor attorney, because that's my opinion. Me saying I believe this complaint is hot garbage, it's not worth the pixels on my screen. That's my opinion. That's protected. It's not defamation. It's not trade disparagement. Of course, we're going to get even more ridiculous as we go further, so buckle up. In particular, Defendant Day has focused her criticism of Attorney Braun for her past representation of her client Caitlin Dempsey, professionally known as Demps. Upon information and belief, Defendant Day communicated with a known stalker and harasser of Miss Dempsey named Erica Fisk. Ms. Dempsey has an active order of protection against Ms. Fisk to stop her from stalking and harassing Ms. Dempsey and her young child. Ms. Dempsey's child is protected by the order of protection. That's irrelevant. It's irrelevant. You're trying to show number one, this is not causing harm to Jeanette Braun. They're trying to show, look, she's harming Dempsey, and therefore rule in our favor. But that's not how it works. That's irrelevant. But they're trying to say, look, she's harming Dempsey by violating a no contact order, by violating a protection order. But that's not happened. The protection order, the stops Fisk from contacting Dempsey or her child. She can't contact her in person, by telephone, by telegraph, by letter, by email, by smoke signals, or by third person. She can't have Ms. Day contact Dempsey for her. Do you know what's not prohibited? Ms. Day contacting Ms. Fisk about Dempsey, to ask her about Dempsey. Do you know what else isn't prohibited? If Miss Day were to contact Ms. Dempsey and ask her about Ms. Fisk. She can't do it on behalf of Fisk, but she can ask her about Fisk. She can say, why do you have a protection order out against Fisk? What did Fisk do to you? What would it take for Fisk to make up to you? Blah, blah, blah. That's not violating the protective order because she's not a protected party. it would also be very unlikely, I don't know the specific state or specific state law, so take this with a pinch of salt, but if Ms. Fisk were to ask Ms. Day to contact Ms. Dempsey on her behalf, and she did, it would be Ms. Day or Ms. Fisk who violated the no contact order because she's the one with the restraining order. Ms. Day, probably no consequences unless there's a specific state law in that state that I don't know about, but it's. But let's say she interviewed Ms. Fisk about Dempsey. And then she interviewed Dempsey, and as part of that interview, she says to Dempsey, now, in my interview of Fisk, she said this. What is your response to that? That wouldn't be a violation by anyone because she isn't contacting her on behalf of Fisk. She's just asking for comment about something Fisk said. So, long story short, this is all a red herring and it's completely irrelevant and yeah. Upon information and belief, Defendant Day also communicated with Kristen Williams, who is a known associate of Miss Fisk and works with her to harass Ms. Dempsey. Upon information and belief, Ms. Williams told Defendant Day about Ms. Dempsey's order of protection. Upon information and belief, Defendant Day contacted Ms. Dempsey after communicating with Ms. Fisk and Ms. Williams while knowing that Ms. Dempsey had an order of protection against Ms. Fisk in part to protect her young child. Upon information and belief, Defendant Day posted a video about Ms. Dempsey after communicating with Ms. Williams to assist Ms. Williams and Ms. Fisk with continuing to harass Dempsey. Once again, that is irrelevant. Ms. Dempsey is not a plaintiff in this case. It has absolutely nothing to do with this case. But as I said in my hypothetical, you can interview the protected party after interviewing the restrained party. That's not illegal. That's not violating. That's nothing. That's just journalism. It's journalism. This is so ridiculous. Harassment campaign against Attorney Braun and Braun Law. In a TikTok story post, Defendant Day created and posted a story on TikTok stating that the Illinois Attorney Registration and Disciplinary Commission told her they received multiple credible complaints about Jeanette Braun, and they have assigned multiple attorneys to investigate this matter. And we have the Instagram, I think, post. Just got confirmation from the Illinois Attorney Registration and Disciplinary Commission that they have received multiple credible complaints about Jeanette Braun, and they have assigned multiple attorneys to investigate this matter. I have an attorney representing me locally and in Illinois now to ensure this woman is stopped. Enough is enough. The Attorney Registration and Disciplinary Commission is the governing body overseeing and regulating the conduct of attorneys. The ARDC operates under the authority of the Illinois Supreme Court, which has sole authority to regulate the admission and discipline of lawyers in Illinois. ARDC overview of ARDC. So that's the citation to that website. All attorney investigations are confidential until the commission brings a complaint against an attorney. Upon information and belief, the ARDC does not comment or provide input on the merits of an investigation to anyone calling to inquire about a registered attorney. Upon information and belief, the Illinois Attorney Registration and Disciplinary Commission would only confirm whether or not the attorney in question was registered, convey the date they were registered, share if the attorney is in good standing, and share if the attorney has ever been found to have engaged in misconduct. As of the filing of this complaint, Attorney Braun is an attorney in good standing and has 0 misconduct violations on her record with the Illinois Attorney Registration and Disciplinary Commission. So here's what's going to happen. If this makes it to discovery, Ms. Day's attorneys are going to subpoena the ARDC. They're going to get the phone records, show that Ms. Day has had phone calls with them. They're going to subpoena the person who had the phone call, if it's recorded. It very well, phone calls to public agencies are often recorded. If it's recorded, they're going to get that. And number one, if that recording says, yeah, we've received multiple complaints, we're investigating, case closed. But they also might, as discovery, they might breach that confidentiality and get information about complaints and investigations. So this could end up being a major Streisand effect problem for Attorney Braun by bringing this claim, because she's suing about it, so the defendants can get discovery about it, and she could have a bad time. And now we have the defamatory statements made by defendants Jessica Vasquez and Lily Marston. Upon information and belief, defendant Vasquez and defendant Marston are owners and co-hosts of the Do We Know Them podcast. And this is one of the videos I did see on Markey's coverage of this, was the Do We Know Them podcast. And their response was basically, bring it, bitch, we'll see you in court. The Do We Know Them podcast is online weekly video podcast that is also disseminated through various audio platforms where defendant Vasquez and defendant Marston promote online controversies, rumors, and celebrity gossip, all of which are monetized. Upon information and belief, neither defendant Vasquez or defendant Marston have any professional training as a news reporter, journalist, or any degrees in those industries or related ones. Once again, irrelevant. Upon information and belief, in fact, you might even make the argument as a defendant that since this involves public figures, since this is likely going to require the heightened level of intent, the reckless disregard for the truth, you might be able to successfully argue, look, the reckless disregard for the truth for a trained journalist is up here, but I'm not a trained journalist, so the reckless disregard for the truth, it is different. I'm not bound by professional standards or an oath or whatever. I'm amateur. That, that could be an argument that a jury would believe, or at least put weight to. Upon information and belief, defendants Vasquez and Marston did not conduct any investigation that involved fact-checking or reaching out to knowledgeable parties to verify the information in her posts. Defendant Vasquez and Marston did not contact the plaintiffs to verify the information in their posts prior to publishing them. In November 2023, the defendants began posting several videos discussing the dispute between Casey and the plaintiffs. In the videos, defendants Vasquez and Marston expressed a strong contempt for Ms. Propson and attorney Braun. Who fucking cares? I am expressing my strong contempt for Ms. Propson and attorney Braun. What of it? I mean, saying the Do We Know Them podcast going on and saying, man, from what I see, I don't like these bitches. That's not defamation. That doesn't belong in the complaint. In the videos, defendants mocked attorney Braun by mispronouncing her name as Janet instead of Jeanette. Now, that is not defamation. That's a schoolyard taunt. That is free speech. Mockery is free speech. Parody is free speech. Them calling you Janet is not defamation. To borrow from a caption above, if they called you that, see you next Tuesday, is protected speech. It may be distasteful, but it's not defamation. We know you're not a gaping vagina. So calling you that thunder, C-U-N-T, that's the first thing that came to my head when I saw the original Illuminati video, was that Blair is that. But them calling you that doesn't mean she's walking snatch. It's not defamation. I hope you all have wonderful visuals in your head right now from this latest dalliance. Defendants identified attorney Braun by her full name and expressly noted that they intentionally mispronounced her name because it was fun, but that they were still referring to attorney Braun. Once again, irrelevant. Not defamation, not harassment. In detailing defendant Casey's disputes with the plaintiffs, these defendants published statements about attorney Braun's clients and her legal practice. In the videos, the defendants stated that reputable and known content creators hire attorney Braun to represent them and take down videos that use their likeness or photographs without their permission. That's a true statement. It's your business. That's what you do. Saying you're a copyright attorney for content creators, that's what you do. That's not defamation. Why is that there? Without discussing the full context of any specific post or takedown, defendant Marston stated that attorney Braun's practices were unethical. And we have the YouTube video, Lauren the Mortician's lawyer is way worse than we thought. Plus Vlog Squad, where are they now? Episode 97 of the Do We Know Them podcast. And the closed caption on the screen says, about a creator she basically goes to like allegedly unethical lengths. Seriously. I wasn't frozen there. I was shocked. That is not defamation. That's not defamation. That is not her saying this is an unethical lawyer who does unethical things. She says, basically, she goes to like allegedly unethical lengths. Allegedly. Now, allegedly isn't a shield, at least not always, but saying, hey, there are allegations that she does unethical things. Let's talk about it. That's commentary. That's opinion. I mean, you know, last Saturday I was at my friend's house. We watched The Big Lebowski. That's like your opinion, man. Shut the fuck up, Donnie. Just stop. Streisand effect. Once again. And then the transcript off to the side can combat the truth coming out about the bullying and harassing of Cody, and that's the common thread. Like, Janet takes down things that are either embarrassing to a creator or negative about a creator. She basically goes to like allegedly unethical lengths to silence people's critics or bullies, as she says, but like, come on, my lawyer, Janet, who has been representing me for a year. She has done my trademarks and my copyright. So anytime anybody uses my image or tries to defame my image and in my business that I have worked my ass off for, and that's the end. So what she hasn't even said, at least not there, that you do false copyright strikes. It's that you allegedly do unethical copyright strikes. You go to unethical lengths, allegedly, to do copyright strikes for your clients if the struck content makes your client look bad. That's not defamation. This whole lawsuit is ridiculous. It's why, for those of you who are new, I called it at the beginning a lawsuit. Following this comment, Defendant Marston and Defendant Vasquez discussed Attorney Braun's other clients to remove posts that misused their intellectual property and images. Following this, Defendant Vasquez stated that Attorney Braun is unethical. So on the screen, is that as unhinged as Janet is, as unethical as Janet is she? So let's look at the whole transcript. That's the common thread we believe, is that Bunny XO, longtime client, has been referring this girl to everybody, and all of a sudden, Janet is way too many people's lawyer. As I said, the crazy part is that as unhinged as Janet is, as unethical as Janet is, she is finding some success in her practices, like whether it's short term or not, but like she's kind of low-key slaying, but in the worst way. Like, she's getting the job done really poorly, but mentioned that to Bekah. I was like, I have to imagine that she has had some success doing all of this, and that's why she's still doing it, because originally my sentiment was like, it's a little bold of someone. So as unhinged as Janet is, as unethical as Janet is, How unethical is she? How unhinged is she? I are they calling you unethical? Once again, this this is up to interpretation. It's did they say Janet is unethical? As unethical as she is, um, as unethical as Janet is, she would never do wrong. This is all bullshit. Upon information and belief, defendant Marston continued to make false accusations and accused Attorney Braun of unethical behavior on multiple platforms. In a since removed post, defendant Marston made further false accusations and referenced Attorney Braun through a past client and accused her of actively committing perjury. And we've got the tweet by Lily Marston. I gotta say, one of our biggest questions in all of this is, do we think Demps knows that her embarrassing excuse for a lawyer is using her name while actively committing perjury? Someone might want to tell her. And so what they're doing here is they're saying that they believe she's committed false copyright strikes. And to file a copyright strike, you're doing it under penalty of perjury. So you're making a sworn statement that you believe this is a breach of your copyright, not protected by fair use. And so if you make a false copyright strike, you're as good as committing perjury. Damage to reputation and harm to Braun Law and attorney Jeanette Braun. As a direct result of the false and defamatory statements made by defendants Casey and defendant Day, Vasquez, and Marston, an angry internet mob was incited to further echo and spread the collective false statements that A. Ms. Propson is transphobic, B. Attorney Braun is unethical, C. Attorney Braun files false copyright claims, and D. Attorney Braun is a rogue attorney. The posts and comments published by the defendants caused their various fans and followers to post negative and one-star Google reviews against Attorney Braun and Braun Law to harm its reputation. Once again, this is not a petting zoo. Do not leave Google reviews. Do not leave nasty comments on Lauren the Mortician's page. I'd recommend not even going to her page, but that's me. In addition, fans and followers of the defendants searched for, contacted, and harassed Ms. Braun's known and suspected social media clients. As a direct result of the negative attention from the defendants' false statements, Attorney Braun lost a potential client due to fear of being harassed for using Attorney Braun's legal services. In addition to the above statements, fans and followers of the defendants are encouraging others to file ARDC complaints against Attorney Braun. Once again, do not file a complaint against Attorney Braun unless you are a former client and are dissatisfied with the service she provided. Or, of course, if you're a defendant that she has gone after and you believe she committed unethical things against you in pursuit of you, but be careful with that because, yeah. But just viewers, don't do it. Not a petting zoo. The continued spread and reposting of these false statements against Attorney Braun and Braun Law caused damage and irreparable reputational harm on a daily basis. So now we're to the causes of action. Count 1, defamation per se. So I'm not going to pull up the elements of all of these causes of action today because this video is already long. I might do a separate video discussing the elements. Let me know if you want me to. So, count one, defamation per se against defendant Casey by plaintiff Lauren Propson. Plaintiff Propson repeats and realleges by reference the allegations in paragraphs 1 through 99 as if fully set forth herein. Defendant Casey defamed plaintiff Propson by publicly stating that plaintiff Propson was a TERF and transphobic and used her platform to attack plaintiff Propson's character and reputation. Defendant Casey made these defamatory statements publicly across multiple social media platforms, including but not limited to Facebook, Instagram, and TikTok. Defendant Casey's defamatory statements concerned plaintiff Propson as they referenced her by her public persona, Lauren the Mortician. The average viewer understood the statements to be about plaintiff Propson. The statements were defamatory because they harmed plaintiff Propson's reputation by lowering her in the eyes of the community and deterring the community from associating with her. The false statements were defamation per se because the harm to plaintiff's reputation is obvious and apparent on its face. Being called transphobic is akin to being called a bigot or a racist, and these defamatory statements caused plaintiff Propson to be viewed by others as transphobic and not an inclusive person. So here's the thing. I mentioned I'm not going to go through the elements of each crime or each cause of action in detail today, but so the standard elements for defamation are: you made a statement, it was false, it was published, and it caused damage. Defamation per se, you can yoink the fourth element. You don't have to prove damage. Just by the very nature, the statement caused damage. So once again, that's statements like you carry a loathsome disease, you've got herpes, it's you are a whore, you are a thief, you embezzled from your company, you being called a TERF, I don't believe is defamation per se. Being called a racist or a bigot, not defamation per se. Now, I'd have to look specifically at Illinois state law, but it's not defamation per se. By plead, they're trying to have an easier time by saying, yeah, this is defamation per se. We don't even have to prove damages. Now give us money for damages. But by doing it as defamation per se, when this doesn't qualify as defamation per se, it's not in the category. This isn't one of the specific things that counts as defamation per se. Like, even if it was defamatory, you lose this count because this isn't defamation per se, even if it is defamation, which I don't believe it's that either. This is bad lawyering. This is bad strategy. This is terrible. I mean, it's great for the defendants, great for KC. But it's just ridiculous in general. Let's see. I need more water. Hopefully this one is still cold. I filled it with ice yesterday. It's moderately. It's better insulated than the other one. These statements resulted in plaintiff Propson losing her contract with a famous documentary channel and a podcast deal that was in its final negotiations. These statements prejudiced plaintiff Propson in her profession and harmed her ability to earn future sponsorships and followers. Defendant Casey's posting to TikTok was an unprivileged publication of the statements to third parties. So remember, I mentioned the elements of the tort of defamation. Publication is one of them. As a proximate result of defendant Casey's publication of false statements of fact about plaintiff Propson, she sustained injuries to her good name, character, and reputation so as to establish presumed damages. If there's damages, I mean, you still have to prove them, but why even plead defamation per se if you're going to also plead damages? As a proximate result of defendant Casey's publication of false statements of fact about plaintiff Propson, she was harmed and continue to be harmed in that she has experienced economic and non-economic damages, including emotional distress and mental anguish, harm to reputation, and harm to her career. Defendant Casey's defamatory statements were made with knowledge of their falsity and with a reckless disregard for the truth so as to justify an award of punitive damages. And once again, they're just glossing over that she's a public figure. But I mean, they are mentioning the reckless disregard for the truth, but they're doing that to justify punitive damages. But they've got to get over the hurdle that she is a public figure. So reckless disregard for the truth, it's a non-starter, like, for any damages, not just punitive. In order to find defamation, there has to be reckless disregard for the truth or knowledge of the falsity. So count 2, defamation against defendant Casey by Jeanette Braun and Braun Law. So plaintiffs reallege, blah, blah, blah. Defendant Casey defamed plaintiffs Braun and Braun Law by publicly stating that Ms. Braun files false copyright strikes and by implying that she was acting as an attorney without being hired by Lauren the Mortician and used her platform to attack their character and reputation. Once again, I believe that is a false statement there. I believe that is a mischaracterization of what Casey said. Because like I said, saying it's a false copyright strike is her opinion. I believe this was a false copyright strike. But saying that she was not hired by Lauren the Mortician, she did not say that. Now, it might be in a video that I haven't seen, but that's not pled here. It's in the GoFundMe. And there it says, if you are not hired by Lauren the Mortician, if you are not, she said, obtained, she should have said retained by Lauren the Mortician, you're gonna have a bad time. If this is misrepresenting what was said, this is bad. Defendant Casey made these defamatory statements publicly across social media. The defamatory statements concerned plaintiff Braun and plaintiff Braun Law, as they referenced attorney Braun by her first name and last name in the documents. The average viewer understood the statements to be about Jeanette Braun, the owner of Braun Law. The statements were defamatory because they harmed plaintiff's reputation by lowering her in the eyes of the community and deterring the community from associating with her. The false statements were defamation per se because the harm to plaintiff's reputation is obvious and apparent on its face, being accused of being an unethical lawyer that files frivolous copyright claims that painted attorney Braun in a false light and incited others to act against her. This resulted in attorney Braun losing potential clients and having others repeat the same false accusations against her. These statements prejudiced plaintiff in her profession and harmed her ability to be retained by new clients. Now, I'm not going to repeat it. I'm not going to call her an unethical attorney. I'm not going to call her a copyright troll. I am going to say I question her practices. I mean, hire her if you want, but you'll rightfully be called out for it, probably. Defendant Casey's assertions regarding Attorney Braun and Braun Law's competency and her legal ethics were intended to harm, discredit, and tarnish Attorney Braun's reputations. Defendant Casey's posting to GoFundMe was an unprivileged publication of the false statements to third parties. Once again, it was not. As a result, it was a publication, but it wasn't a publication of false statements. As a proximate result of Defendant Casey's publication of false and defamatory statements about Attorney Braun and Braun Law, they sustained injuries to their good name, character, and reputation. Because Defendant Casey's statements were defamation per se, damages are presumed. As a proximate result of Defendant Casey's publication of false statements of fact about Attorney Braun and Braun Law, they were harmed and continue to be harmed in that they have experienced economic and non-economic damages, including harm to reputation and harm to her career. Defendant Casey's defamatory statements were made with knowledge of their falsity and with a reckless disregard for the truth, so as to justify an award of punitive damages. And once again, if I make a separate video going over the elements, I'm going to try to look into Illinois specific requirements for defamation per se, because I don't think this qualifies as defamation per se. Although it's maybe it's closer, because I definitely don't think, again, the first one was defamation per se. This one is, there might be an argument actually, because in some jurisdictions, can't remember the exact language, but something career or profession, and can't remember. Can't remember it entirely. We discussed it in Schofield versus Giard, though, so go watch that. And Defendant Casey's defamatory statements were made. We already read that. So count 3, defamation against Bekah Day by Braun and Braun Law. Defendant Day defamed plaintiffs Braun and Braun Law by publicly stating that Attorney Braun was unethical and that she files false copyright strikes without proper investigation and used her platform to attack their character and reputation. Defendant Day made these statements publicly across multiple social media platforms. The defamatory statements concerned Plaintiff Braun and Plaintiff Braun Law, as they referenced her by her full legal name, Jeanette Braun. The average viewer understood these statements to be about Jeanette Braun, the owner of Braun Law. The statements were defamatory because they harmed plaintiff's reputation by lowering her in the eyes of the community and deterring the community from associating with her. The false statements were defamation per se because the harm to plaintiff's reputation is obvious and apparent on its face. Being accused of being an unethical lawyer that files frivolous copyright claims painted Attorney Braun in a false light and incited others to act against her. This resulted in Attorney Braun losing current client and potential clients. These statements prejudiced plaintiff in her profession and harmed her ability to be retained by new clients. Defendant Day's posting to TikTok was an unprivileged publication of the false statements to third parties. As a proximate result of Defendant Day's publication of false statements of fact about Attorney Braun and Braun Law, they sustained injuries to their good name, character, and reputation so as to establish presumed damages. As a proximate result of Defendant Day's publication of false statements of fact about Attorney Braun and Braun Law, they were harmed and continue to be harmed in that they have experienced economic and non-economic damages, including harm to reputation and harm to her career. Defendant Day's defamatory statements were made with knowledge of their falsity and with a reckless disregard for the truth so as to justify an award of punitive damages. Count 4, defamation against The Do We Know Them defendants by Braun and Braun Law. Defendant Vasquez and defendant Marston are business partners that defamed plaintiffs Braun and Braun Law by publicly stating that attorney Braun is unethical and commits perjury and using their platform to smear attorney Braun's character and reputation. The defendants made these defamatory statements publicly across multiple online platforms, including but not limited to YouTube, Twitter, Spotify, Apple Podcasts, Google Podcasts, Castbox, RSS, Pocket Casts, Overcast, Bullhorn, Castro, Player FM, Podcast Addict, Podbean, Podhero, Podcast Guru, Podcast Republic, Podfriend, Radio Public, Sonnet, and subscribe on Android. Boy, I thought I was overdoing it by putting this on YouTube, Facebook, and small clips onto TikTok. Apparently, I'm not ambitious enough. The defamatory statements concerned Plaintiff Braun and Plaintiff Braun Law, as they referenced her by her full legal name, Jeanette Braun. The average viewer understood the statements to be about Jeanette Braun, the owner of Braun Law. The statements were defamatory because they harmed plaintiff's reputation by lowering her in the eyes of the community and deterring the community from associating with her. The false statements were defamatory per se because the harm to plaintiff's reputation is obvious and apparent on its face and blah, blah, blah. This resulted in her losing clients, blah, blah, blah. And the defendants' posts on various platforms are unprivileged publications of false statements to third parties, sustained injuries, blah, 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 harmed, and continue to be harmed and have experienced economic and non-economic damages, including harm to the reputation and career. They were made with knowledge of their falsity and with reckless disregard for the truth. So punitive damages, count 5, false light against defendant Casey by plaintiff Lauren Propson. Defendant Casey's actions in falsely portraying plaintiff Propson as being transphobic and not inclusive placed Propson in a false light. Defendant Casey's conduct placed Propson in a false light that would be highly offensive to a reasonable person. Defendant Casey acted with actual malice, that is, they acted with knowledge that their statements were false or with reckless disregard for whether the statements were true or false. Defendant Casey intentionally mischaracterized her evidence to fit her predetermined narrative. Defendant Casey had reason to know that her actions had the potential to incite large amounts of people to protest and retaliate against plaintiff Propson, and that her allegations needed to be carefully sourced. Nonetheless, defendant Casey made false accusations to attack plaintiff Propson and differentiate her online persona from plaintiff Propson. Once again, they're just conclusorily stating that, well, she acted with reckless disregard for the truth because, you know, even the links she posted as evidence of transphobia, well, they weren't evidence of transphobia. Yet you don't provide the links. You just conclusorily state that they weren't transphobic. You lose. Good day, sir. Don't come again. Don't have a good day. Don't pass go. Don't collect $200. Just get the fuck out. As a proximate result of defendant Casey's publication of false statements of fact about plaintiff Propson, she sustained injuries to her good name, character, and her reputation so as to establish presumed damages. As a proximate result of defendant Casey's publication of false statements of fact about Propson, she was harmed and continues to be harmed in that she has experienced economic and non-economic damages, including emotional distress and mental anguish, harm to reputation, and harm to her career. Defendant Casey's defamatory statements were made with knowledge of their falsity, so punitives. Count 6, false light against defendant Casey by Braun. And defendant's actions in falsely portraying plaintiff Braun as a rogue attorney that was not hired by plaintiff Propson and claiming that she files false copyright claims placed Plaintiff Braun in a false light. It's highly offensive to a reasonable person. Actual malice. Even though you've mischaracterized your claims, at least it appears that way to me. And blah, blah, blah. Count 7, false light against Rebekah Day by Braun, by Janet. Defendant Day's actions and falsely portraying Plaintiff Braun as an unethical attorney, filing false copyright claims, placed Plaintiff Braun in a false light. It would be highly offensive to a reasonable person. It's actual malice. Day intentionally posted several TikTok videos and comments for the sole purpose of creating and monetizing content on her social media profile. That's irrelevant. That's not an element. Defendant Day had reason to know that her actions had the potential to incite large amounts of people to protest and retaliate against Plaintiff Braun and her law firm, and that her allegations needed to be carefully sourced. Nonetheless, she made the false accusations to attack Plaintiff Braun and Braun Law's reputation. And she wants punitives. Count 8, false light against the Do We Know Them defendants by Janet and Janet Law. Defendants, collective actions and falsely portraying Janet as an unethical attorney that commits perjury, placed Janet in a false light. The defendant's conduct placed Janet in her and her law firm in a false light, and it would be highly offensive to a reasonable person. Reckless disregard, actual malice. Defendants intentionally posted several YouTube videos and podcast episodes and multiple tweets for the sole purpose of monetizing and driving traffic to their social media profiles. That is irrelevant. That is not an element. Don't include it. Bad lawyer. Bad. No cake for you. They both had reason to know their actions had the potential to incite large amounts of people to protest and retaliate against Janet and Janet Law, and that their allegations needed to be carefully sourced. Nonetheless, they did it. As a result, punitives. Count 9, trade libel against Casey by Lauren Probson. Beginning in or about November 2023 and continuing through the present, defendant Casey willfully, without justification or privilege, published orally and in writing false, misleading, and disparaging statements about Plaintiff Probson and her beliefs on the LGBT community and transgender rights to third parties, including but not limited to defendant Casey's followers on their Caffinated Kitti social media accounts. Defendant Casey's statements described in this complaint improperly disparaged Plaintiff Probson's services and credibility as a social media influencer by making the false and misleading statement that Plaintiff Probson is transphobic and a TERF. Defendant Casey either knew the statements she was making were false, or she intentionally failed to conduct an appropriate investigation to determine the truth of her claims and not rely entirely on mere speculation and baseless conjecture. As a proximate result of defendant Casey's publication of the above referenced statement, Plaintiff Probson's existing and prospective sponsors have been deterred from sponsoring and otherwise dealing with her as a further proximate result of defendant Casey's publication of the above referenced statements. On information and belief, Plaintiff Probson has endured numerous comments and criticisms that were incited from defendant Casey's false statements that she is transphobic. As a result, Plaintiff Probson has suffered injury to her business and reputation as a social media influencer in an amount currently unknown but believed to be in excess of the jurisdictional amount for this court. Once damages have been determined, plaintiff will seek leave to amend this complaint or will otherwise inform defendant of the damages that are sought. Count 10, trade libel against defendant Casey by Janet. Beginning in or about November 2023 and continuing through the present, defendant Casey willfully, without justification or privilege, published orally, blah, blah, blah. I'm getting tired of this. It's the same thing. False copyright strikes, mob of offensive comments and criticisms, and I want money. And then trade libel against Bekah Day by Janet. And it's basically the same thing. Trade libel against Do We Know Them by Janet. And it's basically the same thing. Count 13, tortious interference with contract against KC by Lauren Propson. And this is basically saying, I had a contract, you tortiously made it so I lost that contract with the well-known documentary company that isn't pled. So that's what that is. Count 14, tortious interference with existing and potential business relationships against all the defendants by Janet. And this is, you caused me to lose clients, you caused me not to get clients, blah, blah, blah. Count 15, intentional infliction of emotional distress against Casey by Lauren Propson. Let's just say no. So regular viewers will know that I say RICO is the legal equivalent of lupus. And that's playing off of the TV show House, where House says it's never lupus. So I say it's never RICO. But intentional infliction of emotional distress is RICO light. It's never intentional infliction of emotional distress. It takes extreme conduct to cause severe emotional distress. Calling someone a TERF won't cut it. It does not cut the mustard. It doesn't even cut the cheese, because this is a fart in the wind. And then count 16, intentional infliction of emotional distress against Day by Lauren Propson. And once again, it's not. And so, wherefore, this is the prayer for relief section, because remember when we looked at Federal Rule of Civil Procedure, Rule 8, there were 3 elements you had to do to properly state a claim. You had to do a statement of why the court has jurisdiction. You had to do a short and plain statement of your claim. And number 3, you had to make your claim for damages. That's what this prayer for relief is. So, wherefore, plaintiff respectfully requests the court to enter judgment in their favor and against the defendants, each of them jointly and severally as follows. Jointly and severally. They didn't act in concert. I'd have to look at the rules again for joint and several liability, but I don't think that this would qualify. But they want award plaintiff damages in amounts pertaining to each of to be determined at trial, but not less than $75,000, including general, special, consequential, actual, and punitive damages. Awarding an accounting to plaintiff for the gains and profits of defendants arising from the unlawful conduct. You're not going to get that, because them making money about talking to you is irrelevant. It's not an element of any of your claims. It's irrelevant. Go away. C, permanently enjoin enjoining defendants and their respective partners, agents, representatives, successors, assigns, and employees, and any and all persons in active convert or participation with defendants, and each of their executors, administrators, successors, licensees, assigns, subsidiaries, parents, affiliates, subdivisions, co-venturers, partners, officers, directors, employees, agents, shareholders, managers, representatives, consultants, and any and all persons, corporations, or other entities acting under the supervision, direct control, or on behalf of any of the foregoing, and each of them from making, disseminating, broadcasting, or publishing any statements that Plaintiff Propson is transphobic, Attorney Braun is an unethical lawyer, Attorney Braun files false copyright claims, Attorney Braun is a rogue attorney, and Attorney Braun commits perjury. No, you are not going to get an injunction for this. That would be prior restraint. What you can do is if they do it in the future, you sue them again. Courts don't tell people not to talk about you or say things about you. They don't prevent it. They might prevent harassment. They're not going to do this. This is asinine. This is abusive litigation, in my opinion. This is ridiculous. D, issue an order requiring defendant Casey to retract, remove, and repudiate in full all defamatory and disparaging statements made regarding plaintiff Lauren Propson. Once again, that is not going to happen. The court is not going to force her to make any statements. At best, they'll tell her, pay money. E, issue an order requiring the defendants to retract, remove, and repudiate in full all defamatory and disparaging statements made regarding the plaintiff Jeanette Braun and plaintiff Braun IP law. Janet. That's also not going to happen. F, awarding plaintiffs attorney's fees and costs and granting plaintiff such other and further relief as the court deems just and proper. Now, plaintiff's fees. I have a feeling it is Lauren the Mortician and Janet who are going to be paying the defendant's attorney's fees, because I believe this lawsuit is a stinker. I believe it was brought in bad faith. Don't sue me for that, Janet. That is my opinion. I believe this is a slap suit. I believe you brought this to silence your critics. Period. Not because you were defamed. I believe you brought it to silence your critics. But it's backfired because Streisand effect. Now, you bring an unjustified lawsuit, you bring a slap suit, you're going to end up paying the defendant's lawyers. Now, as I mentioned, I believe this opens up the defendants to being able to discover what would have been confidential attorney-client privileged communications between Janet and Lauren the Mortician. This could open up Janet to major professional liability concerns. I believe it couldn't happen to a better person, because a better person wouldn't have opened themselves up to those concerns. So, and as I mentioned, this was brought by Benjamin C.R. Lockyer, attorney for the plaintiffs from Lockyer Law, LLC in Chicago, Illinois. And my opinion is that Benjamin C.R. Lockyer is not a great attorney. A great attorney would not have brought this suit, in my opinion. Now, Benjamin Lockyer can join his clients in suing me. But once again, he would have a bad time because I am stating my opinion, which is protected speech. And if you bring that suit, it would be a slap suit. And I would make sure it was an expensive slap suit for you. So that's where I'm going to leave it here. Like I said, there's more to come on this because we've got videos to review and give our opinion on whether they are fair use. I'm going to try to find the links that are allegedly transphobic, give my opinion on that. That's not a legal opinion, of course, because transphobic isn't a legal conclusion. It's opinion. It's a human opinion, not a legal opinion. So gonna try and go over that as well. And we're gonna keep at it. Like I said, there's a grand total of one thing in the docket, which is the complaint we just went over. They haven't even been served yet. Once they're served, there will be 21 days for a response, either a special motion to strike, a 12B6 motion to dismiss, or an answer. So that's what we have. So other than that, I mentioned the other day, I've started a new channel. I've got video up on it now titled Peg Leg Fitness, talking about, trying to hold myself accountable in being good about, getting to the gym more and stuff, and life as an amputee in general. So if you're interested, go check out amputee fitness or peg leg fitness. Sorry. If that's not your cup of tea, that's fine. Let's see. I thought I had something else I was going to bring up. Can't remember. We're caught up on the other lawsuits we've been covering so far. Although I might go back and finish off that the Florida Moors that we've been laughing at because that was fun. Other than that, I probably won't have another video out before Christmas. So Merry Christmas if you celebrate. If not, Happy Monday. And I will see you soon. Oh, no. I remembered. So I've mentioned, channel name Pegleg Finance. So far I've covered legal stuff, but degrees in finance, master's degree, bachelor's degree in finance. And I'm going to start, hopefully in the new year, adding finance content alongside the legal stuff. So if you are interested in participating in that, if I want to do sort of the personal finance breakdown, financial health of viewers, think Dave Ramsey without the right-wing conservative Christian bent, or Susie Orman, that type of stuff. So if you want to do that, send me an email and we'll start planning it. And like I said, hopefully in the new year, I'll start doing that in addition to other finance stuff, not just the financial autopsies. So with that, thanks for joining me. Merry Christmas or Happy Monday. And please do all the YouTube things, like, share, subscribe, bribe your friends and family to do the same. And I will see you next time. Bye-bye.